state has filed its notice of intent to seek the death penalty in the case against Bryan Kohberger, alleging he committed a quadruple murder, killing 4 college students in the dark of night in Moscow, Idaho. In this video, we'll look at that process, what the state has to prove, what the jury has to find, then what happens, appeals, delays, the execution protocols, and generally, if he were convicted and sentenced to death, would the punishment actually occur or just be subject to never-ending delay or later reduction? In that vein, we'll look at all of the 8 cases of inmates currently on death row in Idaho. That's right, there's 8. Some have been there a long, long time, one for 4 decades, and no one has been executed in more than a decade, so you can guess where this part is going. What we won't do is go over whether there should or shouldn't be a death penalty, and whether it is ever or never justified. There are arguments for and against that, of course. It suits me just fine to execute somebody who's taken 4 innocent lives. But on the other hand, there are good arguments against this penalty, including limiting the state's power, the possibility you get it wrong and kill an innocent person, the whole procedure inflicting additional pain even on the victims' families who may support the penalty but find themselves traumatized by the unequal or seemingly arbitrary application or non-application of the penalty. See the Parkland shooting, and when he got life imprisonment, how the victims' families felt there. So however you may stand on the penalty itself, this video is about the reality of it from the legal process standpoint and the practical reality of how it's handled. So let's go. The state has covered the first important step, which is giving notice of its intent to seek the death penalty. Because at least one aggravating factor will later have to be proven by the state, they alleged in the notice the existence of those, as well as far as they know, no mitigating factor that definitely would outweigh the aggravating factor or factors, because you'll see that's what the jury is going to have to decide later. The state says this crime has at least the following aggravating factors out of a possible 11. They're listed in the statute. You've got to have one or more of the statutory aggravating factors. And in this case, they say there was more than one murder. The murder was especially heinous, atrocious, or cruel, and manifested exceptional depravity. The defendant exhibited utter disregard for human life. The murder was committed in the perpetration of another crime, which could include arson, rape, robbery, burglary, kidnapping, or mayhem. So at least one of those applies. Defendant's conduct exhibits a propensity to commit murder, which probably constitutes a continuing threat to society. So that's what the state set out in their notice. Now, setting out these aggravating factors is not just a formality. It's not a PR exercise, because the way the procedure works, they have to prove at least one unanimously to the jury beyond a reasonable doubt. And let's go over that procedure. Under Indiana Code 19-2515, if a person is convicted of murder in the first degree, subject to some exceptions, and the murderer killed, intended to kill, or acted with reckless indifference to human life, they may be subject to the death penalty, even if they did not directly commit the acts that caused death. Sounds like that last part is trying to pick up felony murder. To get the death penalty, the statute says the state must have filed an intent to seek the death penalty, which they've done that in this case. Then, after the conviction, a jury must find beyond reasonable doubt at least one statutory aggravating circumstance. They have to do that unanimous. And then there must also be a unanimous finding that the death penalty should be imposed, considering any mitigating factors. Now, this occurs at a special sentencing proceeding where the jury will hear evidence and arguments in aggravation and mitigation of the offense. If there was a jury in the guilt phase, then that same jury should hear the sentencing part of the case. But if for some reason that can't work, the judge may convene a new jury. If the defendant pleads guilty and the penalty is still on the table, again, see the Parkland shooting, a jury gets impaneled unless the defendant waives it. The jury gets fairly simple instructions for something like this. They have to answer for each alleged statutory aggravating circumstance whether that circumstance has been proven beyond a reasonable doubt. If not, the death penalty is gone. If so, then they answer whether all mitigating circumstances, when weighed against the aggravating circumstance, are sufficiently compelling that the death penalty would be unjust. Now, if they don't answer that unanimously no, so if one person's just like, I'm not sure whether it outweighs it or not, death penalty is gone. If the sentence is handed down, then a stay is automatically made by statute during the special appellate procedures, appeal procedures, and during the pendency of automatic review of a death sentence, which is pretty much how it is in every state that has this penalty. Now let's look at the actual jury verdict form that they have in Idaho. So you'll see part 1 for the jury. We, the jury, render the following verdict regarding the alleged statutory aggravating circumstance. Has the state proven beyond a reasonable doubt that blank, one of those aggravating circumstances I mentioned? No, yes, or unable to reach a unanimous decision. So the first one, no, and unable to reach, that has the same effect, as you'll see. It's yes, where you'd say they do find it, that you would go on. In fact, it says that on the form. If you answered either no or unable to reach a unanimous decision, you do not need to answer any other questions. Simply have the presiding juror sign this verdict form and notify the bailiff that you're done. But if you answered yes, that the state has proven beyond a reasonable doubt an aggravating circumstance, 1 or more, then please answer the questions in part 2. Part 2. And you do this for each statutory aggravating circumstance that they find beyond a reasonable doubt to exist. We, the jury, render the following verdict regarding the weighing of all mitigating circumstances against the statutory aggravating circumstance. And mitigating is something the defense will say, you need to take this into consideration. Here's maybe something to happen of why this guy doesn't deserve the ultimate punishment. That's mitigation. Whereas aggravation is, this is really bad, and it has to be one of those 11 reasons. With respect to the statutory aggravating circumstance that they previously found, we find that when weighed against the aggravating circumstance, all mitigating circumstances are sufficiently compelling that the death penalty would be unjust. Then, of course, it's gone. When weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make the imposition of the death penalty unjust. In that case, you would get the death penalty. Or unable to unanimously decide whether or not all mitigating circumstances are sufficiently compelling that the death penalty would be unjust. And if you find that, there's no death penalty. Once they complete part 2, have the presiding juror sign it, hand it over, boom, you're done. All right, so we talked about in case the jury does find that the death penalty is warranted under the 2 questions that they have to answer, what happens then? Appeals, right? We talked about that, special appellate procedures, a stay. Sometimes there's lots of appeals. But if the appeals are not successful, then what happens? Obviously, if they are successful, you don't get death penalty. Maybe nothing happens, even if your appeal doesn't work. There are 8 inmates on death row currently in Idaho, and the last time somebody was executed was 2012, more than a decade ago. There have only been 3 executions in Idaho since 1976. So it's not exactly a crowded situation and not exactly fast-tracked. There are 8 inmates currently on death row. Let's take a look at them. The first one is Azad Abdullah, and he killed his wife. Received a penalty in 2004. Thomas Creech, he beat an inmate to death in 1983. 40 years ago, he got this penalty. 40 years he's been on death row. What? Here's a guy in 1992, killed a woman during a bank robbery, still hanging around. Let's see. James Hairston, first-degree murder, shot 2 people to death, 1996. Kind of a newcomer to death row in Idaho. Eric Hall, first-degree murder, 2 counts, raping, killing 2 women in 2003. Got the penalty in 2004. Another newcomer, just moving in. Gerald Pizzuto, convicted of first-degree murder, beat 2 people in Idaho County. I think he killed a bunch of other people somewhere else. 1986, he got death penalty, still hanging around. Newcomer got it in 2017 for the shooting death of a police officer. And breaking the glass murder death row ceiling, Robin Rowe, convicted of first-degree murder, arson deaths of her husband, son, and daughter. And she got the penalty in 1993, looking fairly stoked in her picture there. Sounds like a very mean person. But what you can see is a lot of these people have been on death row for a long time, right? 40 years. So it's kind of like, what's the point here, right? So now the Pizzuto guy I mentioned, if my recollection is correct, he killed people in other jurisdictions in addition to the ones that did in Idaho, and he did bad things to people before he killed them. A very bad person. Well, he was being brought up for execution in Idaho, but his case is currently subject to a stay by the federal court there. The state admitted to the federal court that it did not have the drugs necessary for its lethal injection protocol. So on top of appeals and court-ordered stays, the success by groups opposing the death penalty to prevent drug companies from providing drugs to be used in executions, it's created a near permanent stay in many states. Very effective. Death penalty advocates see this success and they're responding to it in some cases by expanding the methods of execution. Idaho has passed a law that if the state cannot get the drugs necessary for lethal injection, then after July, executions would be carried out by firing squad. They're the 5th state now to have this option. Now, firing squad is a good old historical way to dole out the punishment of execution, but it, like many other methods, faded in preference for lethal injection. But as far as the general law goes, a firing squad is still a constitutional method to execute someone. But as firing squads make their way back into the execution scene, expect court challenges based on state and federal constitutions to tie things up for years to come. Given the ability to do lethal injection, will the court still say that, it's not cruel and unusual to shoot somebody? I don't know. And will the lower courts do that? I don't know. Will the state courts do that under their own constitutions? I don't know. The most recent firing squad execution was Ronnie Lee Gardner in Utah in 2010. South Carolina's revised firing squad option has been stayed as litigation based on state and federal claims is underway. I wouldn't imagine it'd be any different in Idaho. So that's the death penalty in Idaho, a reasonably simple procedure that requires unanimous jury findings at the sentencing stage that, if successful, leads to a penalty very rarely imposed. Again, none of this is meant to be an argument for or against the penalty, but just rather a discussion of what the actual lay of the land is. Well, that's it. Thanks, bye.